Good morning and welcome to another presentation. In this presentation I'm going to suggest one of the remedies that is supposed to be available to anyone who's dealing with the federally appointed judge. So if you deal with the Ontario Superior Court of Justice, those judges are actually federally appointed. And if you have a problem with a court case, the general procedure would be to file an appeal. However, in the court case that I dealt with, there was an obstruction with that in the fact that Justice Cjc Dumphy sealed the case at the request of the city lawyer, which is highly illegal. And given this fact, he could not get a court transcript to prove the professional misconduct in that court case. And in fact, in that court case, the city lawyer did not file a proper statement of defense and did not serve it properly. So that entire case in Toronto was fraudulent. And in the case in Belleville, the court actually refused to provide information which would prove the attendance of a court hearing, which I was able to acquire through Zoom. So the court is now aiding and abetting criminal activity, and the judge, which was assigned from Ottawa, because there was a conflict of interest with all the judges locally, allowed perjury and disregarded 150 points in law under the conventional provincial statutes and another 50 points in the federal statute under the Criminal Code of Canada. And the judges in both cases allowed perjury and professional misconduct, which was pointed out, and nobody seemed to care. Now, given the fact that you could not do an appeal in in Toronto at that time, they moved the appeals office to Ottawa, and the Ottawa court is the same one that Ryan Bell works from. And given the fact that the court transcript was sealed, which is another wrongdoing, for those of you that are unaware, a court transcript cannot be sealed unless there is a person in the witness protection program, it is a young offender perhaps, or in the alternative to those two options, it's going to divulge intellectual property, or it's a matter of national defense. There is no provision in there for a simple civil claim. So given the fact that the appeal process was basically off the table, the only other thing a person can do is normally write to the Cjc, which is a Canadian Judicial Council. And so what I had done was I had notified them of all the infractions, outlined it in a well-documented book. It was actually 2 volumes due to the length of it, or 2 separate files, and I provided all the evidence. And that is a direct response basically from the information I provided in my earlier video regarding property rights in Ontario. It was basically that document, slight modifications, but the same information was conveyed. And given the fact that the counsel for the municipality did not file a statement of defense properly in the Toronto case, and is on public record as stating they could not defend the case in Belleville, I should have won both cases. The case in Toronto cost me $3,500, and the case in Belleville cost me $15,000, even though there was no proper defense ever issued. This goes to show you the level of fraud which takes place in the Ontario courts. So, given the fact that an appeal was not possible, I wrote a letter to the Canadian Judicial Council and got them to finally accept it. This document I provide to you now is a response in relation to that document. And you can see here it's supposedly personal and confidential. Well, it's no longer confidential. It says, I'm responding to you in correspondence sent on May 23rd, 2024, in which you make a complaint against the Honorable Cjc F. Dumphy and the Honorable Robin M. Ryan Bell, the Superior Court of Justice, Ontario. You also complain about a lawyer from Templeman LLP, as the mandate of the Canadian Judicial Council in a matter of judicial conduct is for federally appointed judges only. I will only deal with your complaint against Cjc Dumphy and Ryan Bell. Now keep in mind that this case that I'm talking about, or 2 cases I'm talking about, are over the same illegal search that was done by the city officials, unbeknownst to me until a later date. And they did not produce proper identification, which is one of the requirements. And they wrote their own complaint based on the illegal search, which violates a Superior Court case. What the heck is that court case? R versus Lee, where it was done in a federal court, and they said that because the search was done illegally, the information they found in that case was inadmissible. And that case was a criminal case. So if the information is not valid in a criminal case, it would also not be valid in a simple civil complaints case, which never took place, and the city is on record, the city lawyer is, stating they wrote their own complaint. This shows the level of corruption within the current system. This is actually the reason that I make these videos, so that other people hopefully can glean some information from it and not fall in the same trap, or potentially have a remedy. When the system is too corrupt, there is only one remedy, and that's disobedience. The letter goes on to say, in your document entitled Court File CV20273, you refer to various evidences filed in your court matter. And you allege that Dumphy and Ryan Bell ignored that evidence, which is 100% correct. You also make this submission about the evidence because I explained where the evidence follows my understanding. Now it says mandate of counsel. The mandate of counsel in matters of judicial conduct includes determining whether a recommendation should be made to the Minister of Justice that the judges be removed from office by Parliament. So am I not suggesting that they did not follow professional conduct? Yes, 100%. Okay? Now, the reason for removal are set out in Section 80 of the Judges Act and addresses infirmity, misconduct, failure in due execution of judicial office. Well, I would make the argument that when the judge doesn't follow the statute and allows perjury and illegal searches and disregards 150 points in about 3 statutes and another 50 points under the criminal code, as well as cases from a higher court case, that would constitute to me failure of due execution of judicial office. And when a judge is in position, a reasonable, fair-minded, and informed observer would consider incompatible with due execution of judicial office. Well, I would state that anybody that brings in all those arguments, and the judge disregards every point presented, that would be unfair and not operating in compliance with the order. Okay, in the alternative, the councils may determine remedial measures are appropriate in some incidences. Well, I would suggest that they tell the judge he's got to follow the statute and recognize precedent case law. Reasons for dismissing your complaint. Judicial discretion. It is important to note that counsel is not a court, and I agree with that. Counsel has no authority to get involved in court matters. Counsels cannot help complaints or provide them with legal advice. The responsibility and duty of the judge is to rule regarding the admissibility of evidence. Well, I would suggest that photographic evidence, evidence from a higher court, and evidences outlining what the statute says, quoted verbatim from the statute, is good enough evidence. The submissions from parties to control the proceedings before ensure an effective and efficient use of court time. Well, considering that Dumphy had ex parte communications with the city solicitor and possibly other staff, who knows, prior to the hearing, and you're put on hold for about 15 minutes before the hearing conducts to your side, and the judge immediately says, we found you guilty, I would suggest that that is not a fair hearing. And to interpret and apply the rules of the court, well, they didn't do that either, because they're not allowed to have ex parte communications. In order to do that, a judge does not have to remain quiet. I agree, a judge can ask whatever questions he wants. He or she has the discretion, okay, to comment and ask questions. I fully agree with that, yet neither judge did on the evidence and the submissions presented. A judge also has the obligation to intervene when appropriate to ensure that justice is done in substance and in appearance. I agree with that, yet the judges didn't do that. And the court case that suggests it is R versus Murray, 2017, Ontario Court of Appeal. And so it tells you right there what they're supposed to do. and now we have the grounds to go after them. And it says that paragraph 91 and 92. This is not a sign of disrespect. It is disrespect when they don't follow the law. Such functions fall within a bit of judicial discretion. Well, it's not up to the judge to disregard every point in case and law and tell you you've been found guilty when you're the plaintiff in a court case and you haven't presented your case. So the idiot that wrote this letter does not comprehend the context to which he or she writes, or does not follow the rules. Okay? And is not an issue of conduct that fall within the council's mandate. Well, that's incorrect, because you also said that they're supposed to make sure that the court is conducted fairly, and if the judge is found guilty of not doing so, then that is within their discretion. The proper recourse when a litigant disagrees with how a judge exercises his or her discretion, or within the judgment that he or she has made, is the appellate level, meaning you should appeal your case. Well, that means you have to pay the fraudulent people, i.e. the court, when you have to appeal a court case, and given the fact that the case was sealed, the fact that there was no defense provided in the Toronto case, and the judge is on the city solicitor is on record saying they don't know how to defend the case, and I have audio transcripts of both cases which I submitted or suggested I would submit. If they would look at them, then I would say that the Judicial Council is 100% and completely wrong. It says, conclusion, your complaint was referred to me in accordance with Section 89 of the Act. Your complaint was, okay, I'm just going to repeat that. Your complaint was referred to me in accordance with the Act. After reviewing your complaint, which is about 300 and some pages, it is, in my view, does not require further consideration. It does not involve judicial conduct. Well, yes, it does, because the judge didn't follow statute. The judge disregarded 150 points between the Building Code Act and the Municipal Act and the Trespass to Property Act, as well as another 50 points within the Criminal Code of Canada. So, after reviewing my complaint, if you actually had considered any of the points in there, and the fact that the judge disregarded precedent court cases from a higher court, it does require further consideration. And it is judicial conduct as it relates to substance of judicial discretion. The judge is not allowed to throw out every freaking piece of legislation, statute, which it goes against the city solicitor and or the local municipality. Okay? So that is judicial discretion where they're supposed to follow the law. And it says findings of fact will consider in my document states my point, and directly below it, or above it in some cases, there is the statute quoted verbatim exactly what it says, with a footnote which outlines exactly the paragraph within the statute, so you don't have to go through the entire frickin' act. Okay? Now it says, and such other similar matters pursuant to subsection B and subsection C of the Canadian Judicial Council procedure for reviewing complaints or allegations. Well, I proved my allegations, and I provided precedent court cases, all of which were from a higher court, except one, which was the same court, the Superior Court. And then this individual signs it with some name which we can't read. But they're whatever they are, they're the screening officer, assuming their initials are OL. So it's clear to see now that if you go through the Judicial Council, that you will not get a fair hearing or a chance to present your case. And I even offered to give them the audio transcript of the case, and you are perfectly within your legal right to record your own court hearing, as I've proven in my previous presentation. So I hope everyone's found this information relevant or useful, and it further goes to show that the only recourse now is to disregard the statute and disregard the law. I'll remind you of a legal maxim now that says all are equal under the law and no one is above the law. That means if they can disregard the statute, then so can you. Or in this case, so can I. On top of that, the system that we have in court is supposed to operate under the Crown. Therefore, it requires royal assent, which never happens. We've proven that. And under the royal assent, if we want to continue the fraud on the people that the court is operating under the Crown, there's also the Bill of Rights, which has the subjects' rights into it, and nothing can be done to the prejudice of the people. Well, not following a judicial conduct complaint, not following the statute, disregarding international law as well as the Criminal Code of Canada and the relevant legislation, that being the Municipal Act and the Building Code Act primarily, would constitute a complete disregard for the law and the statute. And since all are equal under the law and no one is above the law, we are now in a perfect position to basically take the appropriate action to, disregard them. And this basically is the conclusion of 40 years of harassment that's happened on my family, and they make everything private, and they have private court hearings, which is also illegal. So now the information became public, and they can't say anything about it because they made it public when they had this bogus court hearing and pronounced their side of the story, and nobody's ever seen my side of the story. Well, my side of the story has been conveyed in a different video, which was posted yesterday. Actually, it was posted this morning. Sorry, it was posted this morning, and I received this response today. So that is the conclusion of 40 years. I thank you for taking the time to listen to this presentation, and you can now see the fraud that goes on in the Ontario courts. Thank you. Have a great day.